Lordship, I seek for your Lordship's indulgence in mentioning item number 7 and 8 of part 2. If this matter may be taken after the ensuing vacation, your Lordship.
Why?
My senior, Mr. Johnny, is out of station and due to the death of the
Okay.
relatives.
Have you taken consent from
Yes,
the other
Lordship.
side? Mention is made. You're there before the
Respondent number 2 in 7.
7. Okay. A mention is made on behalf of Mr. Johnny L. Tochong, learned counsel for the appellant, for the adjournment of the matter, which is not objected by Mr. Roshan Subedi, learned counsel for the opposite party. In view of the above, list after the issuing vacations. Yes. Then in 8, again, mention is made on behalf of Mr. Johnny L. Tochong, learned counsel for the appellant, for adjournment of the matter with the consent from the other side. In view of the above, list after the ensuing vacation. Yes.
Much obliged.
Daily list for motion item 1.
Yes.
May I please, Lordship. My Lord, the present writ petition pertains to seeking an appropriate direction from this honorable court for reassessment of compensation, my Lord. And this is the compensation for construction of roads at Thingsai, Bolpui, Sai Pangkwa, Sangao, within Hatil district. And earlier, my Lord, the coordinate bench of this honorable court in WPC 125 of 2021 and 26 of 2023 had already passed an order to the other landowners. These are the additional landowners, and they are exactly in the same status, my Lord.
Yes, so you're saying it's a covered matter.
Covered matter, my Lord, yes.
Yes, counsel for the state government advocate.
Yes, Your Lordship. In this regard, I will have to seek instructions.
What instructions?
Your Lordship, if there might be change in policy or any say that the government might have, if it may be brought on record, Your Lordship.
What policy? 2013 Act instead of the 1894 Act. Previously, you were paid under the 1894, is it? LA
Yes.
Act. Now, okay, let's see. You're saying it's a covered matter.
My Lord.
Okay, anyway,
I-
we'll this thing, we'll
My Lord,
issue
here I'd
notice.
like to furnish one copy of the order passed by your Lordship also.
And Your Lordship, I would have to check also if it falls under
Okay,
the
we'll
same
give them
circumstances.
time, we can dispose it off in the next this thing, isn't
Yes,
it,
Your
if it's a covered matter? Yes, heard Mr. Lalinglian, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the reassessment of the compensation granted to him under the Land Acquisition Act 1894.
My Lord, if I may, that assessment was made under 2016 LA Act.
Okay.
Mizoram Land
Okay, the
Acquisition Act.
Mizoram, yes, yes,
Mal-
under the, who was granted compensation on the assessment made for the acquisition of his land under the Mizoram, within brackets, Land Acquisition, Rehabilitation and Resettlement, close bracket, Act, 2016. By the respondents for the construction of roads at Thingsai dash Bolpui, then within inverted commas H slash Sai C dash what's this, Pangkau dash Sangao Road within Natian district by the 74 RCC within brackets GREF under the Ministry of Defense, Government of India for the maintenance of national security. So, the Learned Council submits that the court in its order dated 21/11/2024 in WPC number 152 of 2021 and in WPC 26 of 2023 dated 25/11/2024 had passed a common order directing for the reassessment of the compensation as per the Right to Fair Compensation and Transparency in Land Acquisition and Resettlement Act 2013. The Learned Counsel submits that the instant case is covered by the said writ petitions and therefore a similar order may be passed. Full stop. Notice of motion be issued to the respondents. Ms. Lal Nuntlui, Learned Government Advocate, accepts notice on behalf of the state respondents, and Ms. Baby Lal so-and-so accepts notice on behalf of the
Respondent number 3, 6, and 7.
respondent number 3, 6, and 7. Requisite copies of the writ petition to be duly furnished to the learned counsels for the writ, respondents. List the matter after.
3 weeks, Your Lordship.
We'll make it after the vacations.
Yes,
isn't it?
Lordship.
Ensuring vacations, wherein the learned counsels for the respondents are given the chance, to get instructions whether the instant case is a covered matter or not.
Much obliged.
Item 2.
May I please, Your Lordship? Lordship, Senior Learned Counsel Mr. P.C. Thamoy is having personal difficulties, so may the matter be listed for tomorrow, if possible.
Yes, you're making a submission on behalf of?
Mr. P.C. Thamoy.
Okay, mention is made on behalf of Mr. P.C. Lalthangmoya for adjournment of the matter, since why the learned counsel is not able to appear due to some personal difficulty. Accordingly, as paid for, list tomorrow's date. Okay, yes.
Pleasure.
List on tomorrow's date, yes.
Item 3.
May I please, Your Lordship? My Lord, this is a second round writ petition, my Lord. The petitioners herein were contract middle school teachers. They had earlier filed one writ petition, and during pendency of that writ petition, my Lord, the respondent authority had a joint meeting, and they have decided to consider the case in their favor under the scheme of 2008 and as well as the recruitment rules of 2003. And in terms of that, the earlier writ petition has been withdrawn with liberty. Thereafter, my Lord, the respondents, while considering their case, had denied considering their case under the recruitment rules of 2003. Instead, they have intended to apply it 2015. And being aggrieved, my Lord, the petitioners are here before this honorable court. In the case of the petitioners, it should be the recruitment rules of 2003,
Instead of?
2015.
Okay, but here, the petitioners have submitted their respective representations
Yes,
dated 23/04/2025. But the respondents still have not taken any appropriate steps till date. So we can dispose of the writ petition by asking the respondents to dispose of your representation submitted on 23/04 within this thing prescribed period of time, isn't it? Then after that,
My Lord, in this case, if I may take your lordship to page number 73,
73.
Annex 14.
So the representation is still pending, isn't it?
Yes, my Lord.
Then,
That is one aspect, my Lord. This page number 73, my Lord. This is the joint meeting minutes of the respondents' authorities, comprising of School Education Department as well as the DPNR and the Finance Department. Page number 3, bottom of the page. Bottom
Yes.
of the page. After lengthy discussion, it was decided that the case of these petitioners in WPC number 162 and those similarly situated primary school teachers be placed before the DPC to consider regularization of their service under the regularization scheme of 2008 as per recruitment rules of 2003 by reckoning their contract service from the date of holding DPC for the continuous engagement as contract teachers, that is 23/5/2013. And this is in our favor.
2013.
Yes,
You
my
want
lord.
the 2013. So
Counting
now they
from-
have not considered. Huh.
Yes, my lord. In spite of this, my lord, in spite of having this resolution by the joint meeting minute, my lord, they have denied page number 78.
Yes.
The relevant portion is in page number 79. Para true. In respect of the following candidates having no MTET, this is under in terms of 2015 rules, may be allowed to continue as contract middle school teachers, and regularization may be considered only after qualifying MTET examination unless relaxation is obtained from DP and AR. This is the impugn, my lord. In spite of making resolution in the earlier meeting with my lord, they have come to this decision, my lord. So, my lord, my humble prayer is that let notice be issued at this
Wait,
stage.
so where's your latest this thing, your representation? Then you said there was a representation.
Yes, my
made,
lord.
Isn't it?
Yes, my
So
lord.
let's see, what was your representation?
Page number 88, and it's 21.
So what is your prayer here? So I'm seeing the nature of your representation, what you have prayed for in your representation, and what you have prayed for in the instant writ petition. If it is the same, then we should give them a chance to consider this.
My
And
lord.
then if for some reason it is not allowed, your representation, then maybe you can file a fresh writ petition.
The earlier writ petition was filed on 2019, my lord.
Oh.
And in that point of time, the plight, the grievance of the petitioner was already addressed by the respondents. But till date, we have not considered for regularization.
Oh. So I've already screened by reading page 105. Okay, I think so. The same representation by each individual,
Yes,
isn't
my
it?
lord. Yes, my lord. The contents
So
are saying.
I have already been screened by DPC on 23/05/2013, and I request you to consider regularization of my service in terms of 2008 as amended from time to time. So this is your representation and your prayer, isn't it?
Yes, my lord.
So in your writ petition, same?
Yes, my lord.
Then let them dispose of, if it's not in your favor, if this representation is not considered in your favor, then you always have the option to come to the court. Now, this is still pending. Let them also do their homework. Why should we do it for them every time if you have a case or not?
My lord, if at this stage notice may be issued and with the liberty to the respondents to consider my case, that there shall be no bar for the respondents to consider my case.
We can dispose it off at the motion stage itself. Who is the counsel for the, yes, she's also present. So we will fix a date give them a fixed time to represent. When did you file your representation? On 23rd April. Very recent, April, isn't it? So give them a chance within, how much? 1 week? No, 1 month.
2 weeks?
Give them 1 month, let them dispose it off. Now it's April, May, June, July, Then if by then nothing is done, then you can come to the court. Make sure that the representation, it was filed in the month of April.
Yes, Your Lordship.
So, we'll issue notice, you'll accept notice,
Yes, sir.
and at the motion stage itself, we will dispose it off with that order. Then make sure that
Yes,
the
sir.
representation is considered within 1 month. That is 3 weeks. We'll
Yes,
make
sir.
it 3 weeks from the date of this order.
Yes, Your Lordship.
And thereafter, let's see. You might not have to have a long hearing in the court. It might be granted also. I'll dispose it of. I'll pass the order later.
Yes, my lord.
Much obliged, Your Lordship.
Within a specific time frame, I say also.
Yes, time frame will be 3 weeks. We'll
Yes, my
make
lord.
it 3 weeks.
From the date of the order.
from the date of receiving the certified true copy of the order. Yes.
For admission, item 4.
This matter pertains to absorption of the RDA employees, my lord. And this morning I have been served with a copy of the absorption order from the
Oh, very
junior
good.
of Miss Mary.
Oh,
And all the petitioners, 25 of them, have now been absorbed in the line department as directed by
Okay.
this court.
so contempt can be closed?
Yes, my lord.
Okay. Heard Mr. Victor L. Radde, learned counsel for the petitioner. Also heard Ms. Lal Nunlui.
On behalf of Miss Mary, Your Lordship.
No, here the government advocate, same thing. Also heard Ms.
But this
Lal
is a
Nun-
contempt case, Your Lordship.
Oh, contempt, yes. So where's Miss Mary?
Your Lordship, due to personal difficulty, she was not able to appear today, Your Lordship.
It is also submitted that the learned counsel for the respondents, Mrs. Mary L. Kiante, is not able to appear due to some personal difficulties. Full stop. The learned counsel for the petitioner has, however, submitted that the respondents have complied with the order of this court in writ petition number
123.
123/2021, dated 17/03/2022, by issuing the notification.
It was on various dates, my lord.
What? Huh?
It was on various dates.
Okay,
They belong to Group A, B, C, and D.
okay, notifications dated 21/05/2025, is it? Just see-
That is one of the.
one of them, dated comma. Then, is it the same department?
Same
Yes.
department.
Comma, then 21/05/2025. Oh, they all are 21/05.
No, my lord. Some are on 5th June.
Okay, 21, then 05/06/2025,
as well as 18 June.
and 18/06/2025, issued by the Directorate of Rural Development, Mizoram, wherein all the petitioners have been absorbed, is it, into the what?
Corresponding post.
Into the correspondent post
Which
of
they
the,
hold- which
of
they
the
hold.
what? Of the
DRDA.
District Rural Development.
Rural Development Department.
Okay, of the district, of the Rural Development Department. Good stuff. He therefore submits that the, since the judgment and order of this court has been duly complied with, this said instant, the instant contempt petition can be closed. Full stop. Having heard the submissions made by the learned counsel for the petitioner, this court has perused the documents submitted, which indicates that the petitioners have been duly absorbed into the rural development department, okay, in terms of this court's judgment and order dated so and so in WPC so and so. Accordingly, this court finds it appropriate to close the instant writ petition,
Contempt petition.
contempt petition number 11/2022. Yes. And therefore stands closed and disposed of. Yes.
Item numbers 5 and 6.
Please, Your Lordship. My Lord, item number 5 and item number 6 was earlier clubbed together. And my Lord, I'm the counsel for the petition in item number 6. My Lord, I would like, first of all, to pray that this matter may not be clubbed together anymore. Because earlier, if I may take Your Lordship to the order passed by Your Lordship on 6/3/2024.
Yes.
Yes, my lord. You will see in the second para of this order that it was clubbed together because earlier there were some common petitioners in both the writ petition. However, the matter has been settled and
Wait, where's the order? 6-3.
6-3, Your Lordship. If you like.
In item number?
I think it was a common, in item number 6,
6-3-2024. There's no 6-3, that's it.
date 6-3, Your Lordship.
14-3 is there. Now before 14, 16-1 is there again.
6 March. My lord, it might be in the item number 6.
Wait. Yes, must be in item number 6. All right.
Yes, it's in item number 6.
Yes.
Yes.
It is seen that this writ petition has been clubbed together with a similar matter in WPC and that the cause title was recast because some names of were previous.
Yes. So, my lord, this matter has it has been settled, and
Okay, so from 75 to 40 numbers.
yes, my lord. So it has been settled. There's no more common. Now, my lord, since the respondents in both the writ petitions are not identical, and on top of that, Your Lordship, if the matter may be kept listed separately, Your Lordship.
Who are the respondents in item number 5?
Item number 5,
And what is the writ petition pertaining to?
it is pertaining to a land acquisition matter,
Land acquisition acquired.
and this is for payment of interest. Payment of interest.
Oh,
And it's a cover matter actually, but the matter has not been taken up for hearing because the council for petitioner number 5 is out of station council. So it's very difficult for the case to
no,
move forward.
someone has appeared through VC.
That is for the
Lordship, I'm appearing on behalf of SK Medhi for respond number 6.
Respondent number,
Respond number 6 in item number 5, Lordship.
item number 5. You're
yes,
the,
6.
huh,
So the NF Railway has no council in 6. They have only in 5 because the respondents are different. So
no. See, in item number 5, who are the respondents?
they are the
NF Railway? No.
NF Railway is there.
Then,
Uh,
then in WPC 136, item number 6,
yes, my lord.
is NF Railway made a respondent?
Yes, my lord.
Then?
There's a chief engineer involved in this case, which is
NF Railways, both of them are NF Railways.
but the
isn't
matter
it?
has been taken differently. But this taking up item number 6, and this SK Medhi is taking up item number 5.
But the matter is the same, isn't
It is
it?
the same.
Then, if we dispose of one item, the other item also automatically will be disposed of. Then it's okay. Just because the councils are different.
Yes.
So now, what is the stage?
Uh,
Because why hear the whole matter again when the issue is the same? Respondent is all the same, only the councils are different, so it's okay. That's no reason for. So in 6, the counsel for the respondent is the Mrs. Iram Sampui, is it?
yes, Your Lordship.
But when the matter is the same, but you're saying that adjournments are being made because in item number 5,
Council
it is
out of state.
Mehdi, and the counsel for the petition is also not present, is it?
Yes, my lord. out of station.
But today
counsel.
also, it appears that Ms. Zaizam Sangpo is not present. What is the stage? Counter affidavits have been filed? In item number 5, have you filed your counter affidavit? Yes. SK Mehdi, has he filed his counter affidavit?
No, Your Lordship. No counter affidavit.
Okay. In
Lordship,
item number 6, have you filed your counter affidavit?
Not yet, my lord.
Yes?
No, my lord.
No. See, it doesn't make any difference, even if we do it separately. So let's see, we'll give them time first to file their counter affidavits. Anyways, both the items have to be adjourned. Had it been that pleadings are complete in one, then maybe because of the constant adjournment, but that is not the case. Yes, when are you going to file your counter affidavit? In item number 5, SK Mehdi. Yes.
Lordship, kindly fix it on 18th of July. My senior will be physically present then on that day.
Okay, before that, you're going to file a counter, is it?
Yes, Lordship.
Because he doesn't have to be physically present to file his counter affidavit. So it appears that before the 18th, counter affidavit will be filed. Is that the case?
Okay,
Yes.
Lordship. We will file.
Okay. None appeared, item number 5, none appeared for the petitioner while Miss, what's your name? R. Saikia, is it?
RRCK, yes, Lordship.
Yes, appears
RRCK.
on behalf of her senior, Ms. SK Mehdi, learned counsel for the respondents / NF Railways, and Ms. Lal Nunloi.
Yes, Your Lordship. If I may also be given, I'm appearing on behalf of respondent number 1 and 2. I may
Learned
be
government
given time-
advocate for respondents number 1 and 2. The learned counsels for the respondents have prayed for time to file their counter affidavit. It is submitted by the learned, it is submitted on behalf of the learned counsel for the respondents / NF Railways that the matter may be listed again on 18/7/20 and that the counter affidavit would be filed before the said date. Accordingly, as prayed for, list on 18/7/2025. Now in PC 136, okay, item number 6, Mr. Jonathan El Silo, learned counsel for the petitioner, is present, while Miss Baby so-and-so appears on behalf of her senior, Miss Zairam Sangpui, learned CGC for respondents number
4 to 7.
4 to 7 and Louis. Learned government advocate for the state
1 to 3, Your
respondents
Lordship.
number 1 to 3 are present. Both the learned counsels for the respondents have prayed for time to file their counter affidavits. Accordingly, list on, again, same date, 18th.
Of nice week.
Item 7.
Wait, please, Your Lordship. Lordship, as per the last court order 2006/2025, I was directed to make necessary correction which I have committed during the filing. So I have compiled it in order and I serve counsel for the respondents as well.
So, yes, have you filed your counter?
Lordship, I will be filing.
You
within
had
a
prayed
week's time.
to allow withdraw, then what about the others?
2, 3, and 4 has submitted their affidavit.
No changes required in your counter, is it? The others?
I have not yet received any instructions, Madam.
Okay. Mr. TC, is it?
Sultan Sangha.
Zotan Sangha, learned counsel for the petitioner, is present and submits that he has made the necessary corrections in terms of this court's order dated 20/06/2025. Full stop. Then Mrs. Caroline Kela Lungoipui, learned government advocate, has prayed to file a fresh counter affidavit against the, in view of the corrections made by the learned counsel for the petitioner. Full stop. Of Ms. Zairam Sangpui, learned CGC for respondent number 1, and Mr. Samuel Vanlashia Tatsangte, learned standing counsel for NHIDCL, is also present. Both the learned counsels have prayed for time to get necessary instructions. Yes. In view of the above, list after 3 weeks.
Obliged.
Item 8.
May it please your lordship, the matter was listed on last Friday, and I was asked to submit the gazette copy of the notifications and the appointing of the direct selling authority. Accordingly, your lordship,
Yes, yes.
I have filed the same this morning, and also, if required, I'll be giving the copy to you as well in this court itself, your lordship.
Yes, so it appears that the writ petition can be closed.
Yes, your lordship.
Okay,
I can approach
since-
the appropriate forum, madam. Now I can approach the appropriate forum since the authority have been
now,
set
now
up.
it's there.
Yes, madam.
So I'll pass the order.
My lord.
Okay, so both the notifications is there. So since your prayer in the writ petition has been complied with and allowed, the instant writ petition stands closed.
Madam, obliged.
Yes,
Much obliged, your lordship.
I'll pass the order later.
My lord.
For orders, item 9.
My lord, this IA 60 of 2025 is for leave of this honorable court to file a third-party appeal. And I had taken steps upon the respondents on 1/5/2025. However, ID card or answer notice has not returned from the respondent number 2.
Okay, one is represented, is it?
Yes, my lord.
Who is respondent number 2?
It's Lal Omi, my lord. I can take steps to Dusty, my lord.
Dusty, okay.
There is some urgency in this case, my lord, because execution proceedings has been initiated
Okay.
before the learned trial court.
Heard Mr. C. Lalthiang Lima.
Si Tlan Thiang.
Lalthiang Lima, learned counsel for the applicant, who submits that since AD card from respondent number 2 is not returned till date, he may be allowed to take steps for service of notice to respondent number 2 through Dusty mode. Mr.
Rempuya.
Lalrempuya appears on behalf of respondent number 1. In view of the above, this court find it fit to allow the learned counsel for the applicant to take necessary steps for each service of notice to respondent number 2 through Dusty mode, and affidavit to that effect is to be duly filed. List the matter after. How long will it take? 3 weeks? 2 weeks?
2 weeks, my lord.
After 2 weeks.
And my lord, I have also filed one IA for stay of the impugned judgment as well.
So
as
this is in the condonation application, is it?
IA 60 is for leave and IA 61 is for condonation, my lord. And
So we have to dispose of the condonation first.
yes,
Okay.
IA 61.
So unless the condonation is disposed of, we cannot proceed with the case. So this condonation application, notice has not been served
Notice has
over.
not been issued, my lord.
Oh, then notice has to be issued. No, the condonation has to be considered first.
Yes, ma'am.
After the disposal of the condonation, only the leave can be considered, isn't it?
There is a
So-
delay of 189 days, my lord.
Oh. So previously, this condonation application was
It
not
was not
brought-
taken up, my lord, yes.
Oh,
Only the leave application.
because you didn't inform the court.
Yes.
How many IAs are there? So we will not pass any order for the leave application. Leave it for the time being. Condonation has to be disposed of first.
My lord.
So you cancel the previous and only in the condonation. Heard Mr. C. So-and-so, learned counsel for the applicant, who has filed the instant application under order 41 Rule 3-A CPC, read with Section 5 of the Limitation Act, 1963, for condoning the delay of 189 days in filing the appeal against the judgment and order dated 19/07/2024, along with the degree dated, no, just make it judgment and degree, okay, dated 19/07/2024, passed by the Court of Civil Judge, within brackets, Senior Division, dash Roman 3, comma, Isol in eviction suit number 10 of 2016. Full stop. Issue notice to the opposite parties. Then Mr. Lalrempuya accepts notice on behalf of respondent number 1. Okay. Opposite party number 1 instead of respondent. Okay. Notice be issued to the respondent number, opposite party number 2 through registered post with AD within 3 days, returnable by 3 weeks.
My lord, if I may be allowed to take.
Since the learned counsel for the applicant has expressed urgency in the matter, the learned counsel for the applicant is also allowed to take steps for service of notice through dusty mode. Affidavit to the effect is to be duly filed, list after 2 weeks. Yes.
Obliged.
Item 10.
Yes.
This IA is for, is an application for stay.
So written
Yes.
objection, if any, we had given time.
Yes, I believe they have already filed their.
Written objection?
Written objection.
So we can dispose of the IA?
Yes.
What is the background?
The Lordship, while filing this regular second appeal.
Okay,
the
to stay the operation of the execution case number
Yes,
so and so
yes.
entitled,
So as per Lordship, while during the course of filing this regular second appeal, the learned executing court has passed an order that is on page 15 of the IA. The relevant portion being page number 17. If I may, Lordship. Para number 2. In view of the above. In view of the above, Honorable Supreme Court of India direction, execution petition shall be decided and disposed of within a period of 6 months without fail. The present case has been filed on 26/2023 for execution of decree passed by this court entitled suit so and so, wherein the judgment debtor were directed to vacate the suit premises and deliver possession of the same to the decree holder within 3 months of from 2/3/2023. However, no actions has been taken by the judgment debtor till date. In the result, this court have no other option but to comply with the above Supreme Court direction in order to evict the judgment debtor from the suit premises so as to hand over the same to the decree holder. Hence, the judgment debtor are directed to vacate the suit premises and deliver possession of the same to the decree holder within 30 days of this order. Further, OC Vivacom PS is directed to ensure compliance of this order without any further delay. With this order, CMA so and so arising out of execution number so and so is disposed of. So this order was passed, Lordship. That's why we have filed the stay of this execution order, execution proceeding. Since we are aggrieved with the judgment and order,
what does it say, the judgment and order?
judgment and order is
This is regarding the condonation of delay, is it?
Yes, yes.
499.
199. It's all interconnected, Lordship. Firstly, we are aggrieved with the judgment and order passed by the London Trial Court entitled suit, and that we have filed in regular first appeal. That regular first appeal was dismissed due to delay.
Okay.
So right now we are filing a second appeal.
So the dispute is over a certain plot of land.
Yes.
Is it?
Yes, between families, between the mother and her son.
Mother and son. You are representing
The
the.
mother.
So they're saying separately.
They are saying separately. So right now, my prayer is that Lordship let the this IAB
So the eviction is to evict the mother. from
evict the
house.
mother. Yes.
Yes.
Lordship, Yes, basically regarding the discussion, actually the mother is also already living separate, means not in this disputed property. In fact, the other children are still living in that disputed
Okay,
property. Actually, yes, but for the namesake, actually this case is
Okay.
proceeded by the mother, in fact. That's
So
it.
eviction of
Eviction of
your
his
brothers or
brother,
sisters?
brothers and sisters.
Yes,
Family, let them
reality.
stay.
Actually,
Till the
yes.
It's all
disposal.
family.
It's among family.
It's all within the family. So the children of the what
respondent.
applicant?
My
No, the
siblings,
children.
my
You're the
siblings.
applicant,
Yes,
isn't
I'm
it?
the-
The children
yes.
of the applicant
Yes.
is also the brothers or sisters of the respondent.
Respondent.
Then we'll allow the IA till the disposal of the RSA. Then let's see. Because it's basically property. Anyways,
Lordship,
why can't we settle the matter, brothers and sisters? Mother is also still living.
Lordship, before that, if I may, this matter is an RSA, Lordship, against the continuation of delay, ordering continuation of delay. However, Lordship, this is a simple matter. I thought it may be disposed of maybe today itself, the RSA, even though the
Notice has to
SDR
be
is
issued again, Lordship, moreover.
Yes,
A
yes.
substantial question of law
So
is to
we
be
will
forwarded.
dispose of the IA,
Yes.
saying that this thing eviction order is state till the disposal of the RSA. Okay. Now in this RSA, I'll post the order later. Okay. IA 81/2025. Okay, I'll pass the full order later. Stands allowed, and the eviction order dated so and so. Estate till the disposal of the so and so. Okay, I'll pass a full order later. Now in the RSA, notice not issued yet. This is the first time it's coming up. No,
Notice upon the
no, notice was
notice was
issued
issued. It's not
on
admitted yet.
01/05/2025.
It's not admitted
So,
yet.
so you're representing, then what are the substantial questions of law? That has
Substantial
not been
question of
framed.
law is on page.
Let's do that.
Page 11 of the memo of appeal, para number 10.
What are your substantial questions
Yes.
of law?
Number 1, whether the learned first appellate court was justified in dismissing the application of condonation of delay of 499 days without construing the sufficient cause liberally and consequently dismiss the appeal without entering into the merits. Number 2, whether the learned first appellate court was justified in dismissing the appeal without considering that a delay was occurred due to approaching the wrong forum.
Okay, you had approached the wrong
Wrong
forum.
forum. Lordship, this judgment and order date is 2/3/2023. 3/2, you know. 1 second.
Okay, we'll fix next dates, we'll form,
Yes.
we'll admit the appeal, and then next date maybe it can disposed of. You come prepared, isn't it?
Yes.
I heard Ms. Malswamy, learned counsel for the applicant, for the appellant. Also heard Mr. Hilal Nunsiam, learned counsel appearing on behalf of the sole respondent, is it?
yes, for the respondent, yes.
On hearing both the parties, the substantial questions of law that is framed as, okay, this is page 11, para 10, okay, 1 and 2. The appeal is admitted. Make it the RSA, okay, regular second appeal. Make it the regular second appeal is admitted. List the matter for hearing. After the vacations?
After the petition. If you oblige.
Item 11.
May it please your lordship,
Maybe please your lordship. This is first appeal against the impugn judgment and order 11/12/2024 passed by the senior civil judge who Aizawl district in civil suit number 46 of 2020. Lordship, in this appeal, there is an unintentional delay of 102 days in preparing this appeal, and a separate application for continuation of the day is also filed.
So
Lordship.
we'll issue notice.
Lordship.
Learned counsel for the applicant who has filed the instant application under Section 5 of the Limitation Act, 1963, read with Order 41, Rule 3, capital A of CPC, 1908, for condonation of 102 days delay in filing an appeal against the judgment and order dated 11/12/2024, passed by the learned civil judge within brackets senior division dash Roman 1 it'll be close bracket Aizawl district in civil suit number 46/2020 full stop. Issue notice to after 3 weeks.
Much obliged, Lordship.
I seek your lordship's indulgence in mentioning item number 10 of part 2, your lordship. Due to paucity of time, if this matter may be listed after the ensuing vacations, your lordship.
What paucity of time? We have plenty of time.
Yes, your lordship. There are fixed matters which are item number 2 and 6, and also, your lordship.
No, 6 is fixed for tomorrow.
Yes, your lordship.
One matter, MAC appeal has been fixed for today.
Yes, your lordship, and also due to personal difficulty as well, your lordship. And I've taken the consent of the opposite party.
Which
as
item?
well. Item number 10, your lordship.
Okay, you're present, Council Deputy Petitioner. Okay. Then we'll fix another on the submission made by the learned counsel. List on.
After the vacations, your lordship.
Okay. You don't want a fixed date? List after the ensuing vacation. Yes.
Much obliged, your lordship.
Hearing list, item 2.
If I may, my lord, in respect of this item number 3, I am for the appellant. Senior counsel, Mr. Liang Shime, is for the
All
private
these
respondent.
mentions should be made at 10 before this thing, isn't it? Anyways,
We are under the impression that this may be taken up maybe today or tomorrow, but there are few fixed items, other fixed items. So
It's okay,
we have
you wait, we can continue. Item number 2 is MAC appeal, it shouldn't take long.
If your lordship can accommodate, will be ready by tomorrow.
Tomorrow we have 2 matters already fixed. Okay, we'll see if, make mention tomorrow.
Yes, madam.
If you cannot,
Yes, madam. Yes,
accommodate, make tomorrow. Okay, yes.
Item 2.
Lordship, this is an appeal against the judgment and award dated 2/11/2023, passed by the MCP Aizawl. And basically, this appeal is preferred on 2 grounds. The one being is that the deceased was unmarried and 50% deduction has to be made, which was not done in this case.
He was a bachelor.
He was a spinster. So,
Spinster.
Spinster.
Okay.
And then 50% deduction has to be done, but that was not done as per the Sarla Varma case. And that is one point. The other point is that is he said to have worked in as a teacher in one of the school by earning rupees 10,000 per month. And that one letter saying that she is earning LPC was signed by one treasurer. But that the signatory was not before the court. One teacher of that same school, who is acquainted to the deceased.
Let's see the TCR, the evidence. Income certificate, is it?
Yes, yes.
Where's the income certificate?
Exhibit C22. C22.
Exhibit C22 is date of birth. Anyways, exhibit, last pay certificate.
Yes.
Okay. Yes, last pay certificate.
Signed by?
Signed by whoever last pay certificate is produced.
Yes, but that is a private school. And was signed by one treasurer, but the one who has adduced evidence before the court was a teacher who is acquainted with the deceased, saying that she used to earn, he know that she used to earn 10,000 rupees, only on that much.
She was a
Whether-
teacher.
Yes, actually whether she was earning or not, that has not been verified.
Okay, that's your
From
point.
the school,
huh?
yes, from the school. That is in
What
the
else?
evidence.
Those two
Yes,
matters.
yes.
huh?
That is in the evidence
Okay,
of,
so let's see the evidence.
yes, yes.
Now, at the time during the learned tribunal, was the income certificate objected? Let's see the evidence. Before the court.
Yes.
So the teacher appeared as witness number?
Witness number 3, R. Lal Swanoma. R. Lal Swanoma.
Yes, R. Lal Swanoma.
Uh,
So this is the in chief.
yes, yes.
Now in the cross,
Cross is there, yes. Number 4. It is a fact that Exhibit 3 C22 is prepared by the treasurer Helen Lowry's Higher Secondary School Aizawl and not by me. I denied that the deceased employee was not paid so and so. I decided that the mode of payment of salary was in cash mode payment. The deceased employee joined the said school in the year 2018 as a teacher for mathematics in the class 9 and 10. Next, it is not. I do not know whether the school authority maintain a cash register book regard her mode of payment of salary, and I am not the office staff of the said school. It is a fact that today I do not have any document proof to show that Lal employee was earning rupees 10,000 per month, except C22 annexed and exhibited by CW1.
who is CW1?
The claimant, mother.
Claimant is the father?
Mother.
Mother?
Yes.
Okay. What does she say about her income? Just that, only that, huh?
Yes.
Okay. Yes, those 2 points?
Only on these 2 points. And then
Any
my submission is
citation?
the 50% regarding the
Any authority?
exhibit. I have one citation. 2003 8 SCC 745. Paragraph number 16.
Yes.
What was exhibit?
Please read.
Reliance is heavily placed on behalf of the appellant on the case of Ramji Dayawala so-and-so. The legal position is not in dispute that mere production and marking of a document as exhibit by the court cannot be held to be a due proof of its contents. Its execution has to be proved by admissible evidence, that is, by the evidence of those persons who can vouchsafe for the truth of the facts in issue. That is my submission, saying that mere exhibit cannot be, mere marking of a document as exhibit by the court cannot be held to be due proof. The executant of that document has to come before the court and prove that it was actually signed or otherwise prepared by him. And then in this case, the treasurer who was the signatory was not before the court. One of the teacher who is acquainted with the deceased came before the court, and he also stated that he doesn't have any proof regarding the income of so and so. That is one point. And regarding the
the issue of deduction of 50%, I'm relying on Sarla Verma case, that is
Okay, Sharma Parvat,
Sarla
please.
Verma paragraph number 31. Your Lordship is very well aware of that. Deduction of 50%, that much. And my submission is that 50% deduction has to be made in this case, which was not done. And the second point is that the income has not been proved because the signatory
So how
is not
much should she earn?
10,000 rupees.
So how much should she earn? What will be the notional income? She's a teacher, that's not been denied.
Yes.
How much do teachers earn?
That is up to Your Lordship. On
Anyways,
that point, Your Lordship is much aware of it, but regarding the 50% discount, that has to be
okay,
modified.
yes. Yes.
Okay, please, Lordship. My Lord, with regard, the appeal is confined to quantum of award. This is a cover matter. So far as maintainability of appeal by the insurance company is concerned, National Insurance Company Limited versus London Pari, the coordinate bench of this honorable court had dismissed the appeal due to absence of leave under 173 MV Act. In this particular case, no leave was obtained by the appellant from the tribunal.
Let's see, what is this?
This one is relied upon by Josephine Joseph James versus. So, this appeal against quantum of award is maintainable in the absence of leave under 170 MV Act. Page number 7, para number 16. In the present case as well, the admitted position is that the appellant insurance company did not obtain permission under section 170 of the Act. Therefore, in view of the decision of the Apex Court in Nicoletta Rotagi and Rekha Jain Supra, there is no scope for considering the instant appeal on grounds
What is 170? Let's see. Please read 170.
impleading insurer in certain cases.
So before the tribunal,
Yes,
they were not a party.
they were a party.
Then,
They were party.
oh, so how is this case applicable?
But here in this judgment, 29 March 2019, coordinate bench of this honorable court has dismissed the.
But the facts are the same.
Yes. During trial, no leave under 170 was obtained by the appellant.
To be impleaded, isn't it? If they were not impleaded,
They were already impleaded
then,
at initial stage.
then,
So, but no leave was obtained by the insurance company.
what sort of a leave?
Leave permission to challenge quantum of award.
Read 170B.
By the person against whom the claim is made has failed to contest the claim. By the person means owner of the vehicle.
See here, anyways, what are the facts of the case here in the judgment which you have just cited?
My lord, in this particular case, compensation was awarded by the tribunal, and the appellant insurance company has challenged the quantum of award before this honorable court, and before this honorable court has dismissed the said make appeal due to absence of leave under 170 on the part of the appellant, because the appellant during the course of trial has not obtained leave under 170 to contest the case on ground in addition to 170 MV Act. So quantum of award cannot be challenged under 173 unless leave under 170 is obtained by the appellant.
Before the court, isn't it? Trial
Yes,
court.
yes.
No. See here, what happened was notice was not given. And then there has to be, you have to satisfy that there was a collusion.
Yes. Since the insurer and the
So show us that there's some collusion between the insurance and the
because
party.
presence of collusion cannot be proved because the insurer has not contested the claim petition in the trial court or in the before the tribunal.
Okay, yes, what do you have to say concerning this?
My lord, I'd like to
Because here it is
Produce one-
admitted, it is on the admission of the respondents, that we are not admitting anything, yes.
regarding
Let's
this
see
issue.
this,
I'd like to produce one judgment. 2011, 10 SCC 509. This is Sheila Datta, United India Insurance Company Limited versus Sheila Datta, paragraph number 14. Page is 509. 509. 2011, 10 SCC 509.
yes.
Paragraph number 14. My lord, I may read. When an insurer is impleaded as a party respondent to the claim petition, as contrasted
Wait,
from...
wait, yes.
Yes. When an insurer is impleaded as a party respondent to the claim petition, as contrasted from merely being a noticee under section 1492 of the Act, its rights are significantly different. If the insurer is only a noticee, it can only raise such of those grounds as are permissible in law under section 1492. But if he is a party respondent, it can raise not only those grounds which are available under section 1492, but also all other grounds that are available to a person against whom a claim is made. It therefore follows that if a claimant impledes the insurer as a party respondent for whatever reason, then as such respondent, the insurer will be entitled to urge all contention and grounds which may be available to him, to it. This is very clear. If the insurer is the party respondent, not a mere noticee in this case. Notice was served, contested by the insurer, they were the party respondent. So this judgment has clarified all.
So 170, when is it applicable? you see?
If it is a mere noticee, then only it will be. it will come into play.
That's why I'm saying, what are the facts of the case? Anyways, anything else?
My lord, in that
So you've challenged the maintainability. What about the grounds?
my lord, para number 22, sub number 2.
Of what?
Point, United India Insurance Company versus Sila Data, same citation. Point number 2, 3, 4, 3 to 5, which may come in conflict with Nicoletta Rotaki are referred to a larger bench. We accordingly direct these matters, that is, cases where insurer alone was the appellant before the High Court and where the insurer was only
We are
a
reading from
noticee.
where? Para which?
Para 22,
Para
sub
20.
number 2.
2.
Yes.
Okay. Just go up sub number 2.
Yes.
Huh.
And not impleaded
Sub,
respondent.
this is 1. What you're showing me is 1. Go up. Huh. Para 22.
2. Sub para 2.
2.
Yes.
There's no sub para 2, is it?
Yeah.
It starts from 6. The question, is it? Are you reading the question, however?
My lord.
Is it?
Yes.
It's 6, huh?
Yes.
Please read.
And not impleaded respondent in the claim petition to be placed before the Honorable Chief Justice for constituting a larger bench to consider points raised by
Where
the
are you reading
insurers.
from?
So,
Your Lordship, it's in paragraph.
where is
36
the
from
outcome?
SCC.
Para
36 in SCC.
36.
SCC,
Okay,
para
para
36, point
36.
number 2. 36.
36.
Yes, 36 para.
para number 2.
Point
Yes.
The matter was referred for constitution of a larger bench to consider points 2, 3, 4, and 5 raised by the insurers. So, where is the outcome? Let the learned counsel for
This
the
is which
claimant.
date this judgment is? 2000?
My lord, October 13, 2011.
So
Yeah.
there must be judgments after that. I don't think you have a point here.
No, no.
Anyways, so we will see. I've seen this thing. We have to look at 170
Well,
properly.
No.
Okay.
Here also.
Whether, and then concerning she being a spinster, 50%?
Yes.
My lord,
And
in
the
one
other point which-
authority also, Josephine James versus United India Insurance Company. Yes. Date of decision 14 August 2013. Here, appeal filed by the insurance company was dismissed due to absence of leave under 170.
So 170, when is it applicable? That has to be seen.
Yes.
Anyways,
That much.
then the next point, being a spinster and the income.
The income is 10,000. Yes.
10,000.
Yes.
But he says that the authority who signed on it was not examined. What do you have to say concerning that?
As per this authority, Josephine James,
Yes. What does it
the
say?
insurance company has not, who has no leave under 170.
Besides that point, that we will look. Okay.
Yes.
Now his other grounds for appeal. Anything on that?
Yes. The other ground, like
Being a
proof-
spinster, 50%, that already covered by Sharla Verma's case.
Yes.
Then concerning the income, he's saying that it is not proved. What do you have to say concerning that?
Oh, it has been proved because
How?
treasurer of the school is somewhat like drawing and disbursing official in any particular office.
Yes.
So
The treasurer was not examined. That is point. He did not come. One of the teachers came.
the
So
The
what do you have
claimant-
to say concerning the income?
the claimant has proved the income of the deceased because the first claimant is the mother. So mother is supposed to know the income of the salary of the daughter of or son because this is somewhat like fixed or round up salary, unlike government employee, other government employee. The deceased was a teacher at Helen
Teacher,
Lawrence School.
yes. That has not
Yeah.
been denied,
Yes.
isn't it?
Yes.
So usually teachers, their
Yes.
income should be
yeah,
around that much.
the deceit was hold MCOM gold medalist. So for
Oh,
the
she's income gold medalist, is
yes,
it?
yes. So for her, for that person, 10,000 also is very
Okay.
small, actually, and in reality. So
Yes.
although it was not mentioned in the evidence yet, at the time of the after the instant case was filed, the insurance company verified the income of the deceit in the state school, and
Where?
they cannot.
He has an insurance company, he has not.
Although it was not mentioned in the state evidence, but after closing all the evidences, it was mentioned that the insurance company
Okay.
inspected the
The
income.
insurance company is here.
Yes, they
Did you
inspected.
verify?
No, that aspect has not been,
He doesn't know.
Yes, but
it has not come into the picture.
Do you have evidence of that?
but after closing the evidence, it was informed to me by
That is
the
To you.
the statement of the claimant, not the insurance
That we
company.
can't accept because
Yes.
insurance company is here.
Yes.
But where's the evidence saying that she was a
No.
gold medalist? It's there in
that
evidence?
that inspection was not is not appear in the evidence. After we closed the evidence, that
It should be
information
there in
was
evidence,
simply
So the mother should be
informed,
knowing that she was a
Yes.
gold medalist. Did she mention in her evidence that
My
she
lord,
was
it
a
was
gold
mentioned.
medalist? Yes?
Moreover,
It was
that-
mentioned or not
that
mentioned?
document was also annexed in the claim petition.
It was mentioned.
Yes.
It's there in evidence. Okay,
Yes.
fine. If you say that, it's good enough. I'm not going
Whether
to.
we say or not is one thing, but that document is annexed
It's
in the
there.
claim petition.
Okay, good enough. That she
And the
was a
mother,
gold medalist.
mother had exhibited that
Oh, then
certificate.
good enough.
Exhibit C31.
My lord, one more submission.
Oh,
The land, although we have not filed cross appeal or cross objection, yet this honorable court has authority or inherent power under Order 41 Rule 33 to award just compensation in line with Pranay cases, because the claimant filial consortium amounting to rupees 40,000 is not awarded to the claimant, so it has to be awarded.
who's the filial this thing?
Filial consortium, the claimant mother is entitled filial consortium because her daughter died in the accident as mentioned herein before, so she claimant respondent number 1 entitled rupees 40,000 under head just compensation. I have
Let's see, what judgment do you have?
yes. Page number 4. Subpara 3. Filial consortium is the right of the parents to compensation in the case of an accidental death of a child. An accident leading to the death of a child causes great shock and agony to the parents and family of the deceased. The greatest agony for parents is to lose their child during their lifetime. Children are valued for their love, affection, and companionship and their role in the family unit. Here, it was awarded. Moreover,
Yes.
here also this authority, Magma General Insurance Company Limited versus Nanuram Allies, Churaram, and others. This also explain about this filial consortium in the case of death of son or daughter. filial consortium is available in the case of death of son or daughter. And the
Okay.
parents are entitled. So, whether
So where's the second, the same authority?
filial compensation is omitted by the trial court. So
So
this
what
other-
is the deduction made by the learned trial court? If it's not the same 50%, any deduction made?
Deduction. No deduction.
No deduction?
No deduction.
My lord, if deduction, 50% deduction is made, the admissible amount will be 15,45,000 plus 40,000 filial consortium. I have already worked out in that event.
Yes. Heard Mr. Rosen Subadi, learned counsel for the appellant. Also heard Mr. L. Rimtluanga, learned counsel for respondent number 1/claimant. Having heard the submissions made, no, instead of that, hearing concluded, matter reserved for judgment.
Item 13.
Obliged.
May I please, Your Lordship? My Lord, the respondents are not available today.
Have you contacted them, found out what's happening?
Yes, it was fixed by them actually. Today is fixed, prayed for by the respondents as a fixed date.
Why have they not appeared? Anyway,
If Your Lordship permits, a date may be given for the next
Okay.
hearing. my Lord.
Mr. Lalbiak Dungan Hamte, learned counsel for the appellant is present, while none appeared for the respondents. Now, you were supposed to try and make an attempt to come to an
Yes,
amicable
but
settlement.
we cannot make a
Yeah,
settlement, my Lord.
Okay. It is submitted that though the parties have tried to make an attempt to come to an amicable settlement, no settlement could be arrived at. In view of the above, as prayed for, this on, give a date,
17th of July, my Lord.
on 17th, 7/20/25. Yes, inform this thing also.
Yes, my lord.
respondents also.